Saturday. The Department of Justice is at war with itself. Not leaks, not rumors, war. According to internal communications obtained this week, Attorney General Bondi disclosed terms of private family arrangements. I've got the documents. Page 11 shows Bondi personally signed off on a deal framework involving Trump family legal exposure. Here's what they're not covering. Page 17, a specific immunity-adjacent arrangement structured to avoid criminal prosecution was being negotiated while DOJ publicly denied any such discussions. That's the filing, not speculation. But that's not the worst part. The people inside DOJ who found out about these private deals, they're not staying quiet. Internal dissent has now reached the Inspector General's office. 72 hours. That's how fast this escalated. Let me show you what's in these documents. Quick context. Pam Bondi, Attorney General of the United States, former Florida AG, confirmed in 2025.
The issue, credible reports that Bondi facilitated private deal negotiations involving Trump family members facing active federal legal exposure without full DOJ transparency protocols. Timeline, fast. 3 weeks ago, internal DOJ memo flagged unauthorized communication channels between AG office and outside counsel representing Trump family interests. 10 days ago, Inspector General received formal whistleblower complaint from 2 senior DOJ attorneys. Today, documents outlining the scope of those private deal discussions are now being reviewed at the highest levels of federal oversight. That's the setup. Now, what's in these internal communications that everybody missed? The documents. Page 11. Bondi's office initiated contact with private counsel representing Ivanka Trump and Jared Kushner on February 6th. Direct quote, AG authorized preliminary framework discussion outside standard channels. That's procedure violation at minimum. Page 17. Framework discussed included deferred prosecution language, effectively shielding family members from charges tied to ongoing financial investigations. Conditional non-prosecution contingent on cooperation parameters connects to the first finding. Bondi's office didn't just communicate, they drafted terms that benefit the family she serves under. Gets worse. Page 24, a second set of communications, separate track, shows White House counsel's office was looped in before DOJ's own public integrity section knew this was happening. White House knew. DOJ career prosecutors didn't. 3 findings, same pattern. AG initiated contact with Trump family counsel directly. Non-prosecution framework drafted outside standard channels. White House informed before internal DOJ oversight, all documented. Pages 11-29. But wait, page 31. The whistleblower complaint references a specific meeting on February 14th over Valentine's Day at a private location outside DOJ headquarters. No official log, no security detail record, no calendar entry. That's not an oversight. That's concealment. Timeline proves intent. February 6th, initial contact initiated February 14th. Off-site private meeting, February 24th. White House counsel briefed March 3rd. Inspector General complaint filed 25 days from first contact to federal whistleblower complaint. Fast and ugly, subscribe, more documents dropping on this. Thursday, 6:23 p.m. Here's what happened. 2 senior DOJ attorneys, career prosecutors with a combined 34 years of federal service, formally submitted whistleblower disclosures to the Inspector General's office. Attorney General Bondi engaged in unauthorized communications with subjects of active federal inquiry. DOJ press office silent for 2 hours and 11 minutes. Immediate consequences. Inspector General opened formal preliminary review within 90 minutes of receipt. Senate Judiciary Committee notified by 8:47 p.m. 3 career DOJ officials placed on administrative leave by 10:15 p.m. Not the ones who filed the complaint, different officials. Ones who allegedly facilitated the meetings. 4 hours. That's how fast this moved. While everyone focused on the administrative leave announcements, IG simultaneously issued a document preservation order to the AG's office covering all communications from January 20th forward. Every email, every text, every calendar entry. White House counsel's response asserted executive privilege over a specific subset of communications at 9:52 p.m. That's documented in the IG's preliminary review docket. Privilege assertion over documents in a DOJ internal investigation means they believe something in there is damaging enough to fight for. Bondi's office released a statement at 11:07 p.m. The Attorney General has acted fully within the bounds of her authority and will cooperate with any appropriate review. Not a denial. Not these allegations are false. Like, cooperate with appropriate review. They're already arguing about what's appropriate. This changed everything. Like, if you're seeing what I'm seeing here, here's what nobody caught. Exhibit C inside the whistleblower complaint references a financial component to the deal framework discussions, specifically a tax liability arrangement connected to the Trump Organization's ongoing New York State exposure. This wasn't in any news coverage. This is the part that changes everything. The connection, the non-prosecution framework Bondi's office drafted wasn't just about federal criminal charges. It included language coordinating with how state-level tax investigations would proceed, something the federal DOJ has no formal jurisdiction to negotiate. They were trying to solve problems they legally cannot solve. Numbers tell the story. $457 million estimated Trump Organization state tax liability currently under review. 3, number of separate financial investigations the framework allegedly addressed. 0, number of times DOJ's tax division was consulted before the framework was drafted. 0. They went around their own division. Why this matters? If DOJ negotiated arrangements touching state tax matters, that's potential interference with state prosecution, a separate federal crime. Former DOJ Tax Division Chief Richard Delgado confirmed Thursday that no interagency coordination request was filed. Quote, standard protocol requires tax divisions sign-off on any federal-state coordination. That's independent confirmation the protocol was broken. This changes the scope from internal misconduct to potential obstruction of state proceedings. How we got here. 14 months ago, Bondi confirmed as AG, Senate vote 54-46. Critics raised conflict of interest concerns given her political history with Trump, dismissed as partisan. 8 months ago, first reports emerged that DOJ was quietly winding down certain investigations touching Trump-adjacent entities. Career prosecutors raised internal objections. Nothing public. 3 weeks ago, internal memo leaked to oversight channels. That memo became the foundation of the whistleblower complaint. Quote from that memo filed internally 8 months ago. Prosecutorial decisions appear influenced by factors external to legal merit. What happened in between? You're right. 2 U.S. attorneys resigned rather than implement certain directives. Public integrity section restructured, removing senior career staff. AG's scheduling records were restricted from standard FOIA access each time. Explanations were offered, reorganizations, policy updates, personnel decisions framed as routine until 3 weeks ago. What broke the pattern? 2 career attorneys decided the February 14th meeting was a line they couldn't let pass in silence. Stay with me. What experts are saying changes this. What experts are saying, former DOJ Public Integrity Section Chief Thomas Malone, 21 years federal prosecution. AG-level contact with subjects of active inquiry is textbook ethics violation. Translation, this isn't a gray area. The rule exists precisely to prevent what these documents describe. Former federal appellate judge and DOJ oversight scholar Professor Diane Chu, privilege assertion over IG documents signals awareness of legal exposure. Keyword awareness means White House counsel believes those documents show something indefensible. Even former Trump DOJ official and conservative legal commentator Robert Tanner. If the February 14th meeting is unlogged, that's the problem, regardless of what was discussed. When a former Trump DOJ official says the logging failure alone is the problem, both sides see it. Consensus. Unauthorized communications with subjects of federal inquiry violates DOJ ethics rules. Offsite unlogged meeting creates obstruction exposure independent of deal content. State tax coordination without tax division approval is separate potential violation. That's professional analysis, not spin. Former FBI general counsel whistleblower complaints from career prosecutors carry enormous institutional weight. These aren't political actors. Constitutional law professor at Georgetown, executive privilege does not cover communications that are themselves evidence of a crime. That's the crime fraud exception. Former Inspector General of the DOJ, Glenn Fine. Preservation orders this broad, issued this fast, indicate the IG found immediate credible basis. They don't do that. FlexFixX. Former U.S. Attaché, Southern District. 3 separate investigations addressed in one framework document. And that's not a conversation. That's a coordinated legal strategy for the benefit of specific individuals. Multiple backgrounds, multiple ideologies. One read, "This is serious." Fair counterpoint. Bondi's allies say the AG has broad discretionary authority over prosecutorial decisions, and that communications with counsel representing individuals under inquiry are not inherently improper. Their case, attorneys general routinely engage with outside counsel on complex matters involving high-profile figures. It's part of managing institutional risk. The whistleblower complaints represent disgruntled career employees opposed to the administration's policy direction, not witnesses to actual misconduct. Former AG under George W. Bush, Michael Mukasey. Charging decisions involve extensive deliberation. Not all of it is formal or documented. That's legitimate. What they have, no direct evidence yet that any deal was finalized or executed. Whistleblower complaints are allegations, not findings. Even a former Obama-era DOJ ethics official acknowledged the line between appropriate prosecutorial discretion and improper influence is genuinely contested in some cases. But the February 14th meeting has no log, no record, no official trace, and the White House immediately asserted privilege when documents were requested. That's not discretion. That's concealment. Both sides have arguments. Documents say the meeting happened off record, the framework was drafted, and the moment investigators asked, a privilege wall went up, like if this breakdown is useful. Why this matters to you, if you've ever faced the legal system, the core promise of American justice is that it applies equally. What these documents describe is a 2-track system. One for families with direct access to the Attorney General, one for everyone else. Numbers 330 million Americans subject to federal law. One family allegedly negotiating private terms with the person who enforces it, who your exposure, every federal investigation you could ever face would be handled through documented channels, formal procedures, and no off-site meetings. The precedent, if a sitting AG can negotiate non-prosecution frameworks for the family of the president who appointed her without internal oversight, without tax division sign-off, without a calendar entry, the mechanism that's supposed to prevent that just failed in real time. Example, you own a small business, you're under audit. You face potential federal tax liability. You go through the IRS, the DOJ tax division, documented procedures, lawyers, formal process. The Trump organization allegedly had a different experience, a framework, a private meeting, a Valentine's Day conversation with no official record. Who gets hit? Every American who assumes federal law enforcement operates on documented, reviewable, equal process. Bottom line, if you believe justice shouldn't depend on who you know inside the building, this case tests whether that's still true. What people are doing, contacting congressional representatives demanding IG report be made public, following Senate Judiciary Committee hearing announcements, knowledge helps. How Bondi responded made it worse. Friday morning press briefing. Bondi appeared, took 3 questions, called the whistleblower complaints a coordinated political attack by holdover Obama-era bureaucrats. Quote, career obstruction dressed up as whistleblowing. Reaction, both whistleblowers' attorneys confirmed clients are Trump-era appointees, not Obama holdovers. Statement was factually false within 6 hours. Senate Judiciary Ranking Member announced subpoena preparation by 2 p.m. 4 additional DOJ career attorneys filed supporting declarations with the IG by end of day. Then, Friday evening, Bondi's office released a supplemental statement claiming the February 14th meeting was a routine policy discussion, but still provided no log, no attendee list, no location confirmation. Inspector General's office response issued second. Preservation order expanding scope to include all AG scheduling staff communications. They didn't accept the explanation. They expanded the investigation, not de-escalating, calling whistleblowers politically motivated. Here is the kind of a factual error that makes investigators look harder, not less. Every false public statement becomes part of the record being assembled. Bondi's credibility with the one institution that matters right now, the Inspector General, Pam Bondi, took a direct hit today. What's coming? Wednesday, April 22nd. Inspector General's office completes preliminary review, decision on whether to open full formal investigation. 3 possible outcomes. 1. IG opens full investigation. Bondi's office enters formal oversight. Document demands escalate. Congressional pressure intensifies. 2, IG refers to special counsel, removes DOJ internal review, creates independent prosecutorial track, exponentially higher stakes. 3, IG closes preliminary review. Bondi's team claims vindication. Whistleblowers face potential retaliation scrutiny. Story shifts. Former DOJ Inspector General counsel says outcome. 1, most likely because the breadth of the preservation orders already issued signals the IG found enough to proceed formally. Also scheduled Monday, April 21st, Senate Judiciary Committee convenes. Vote on whether to issue subpoenas for February communications. Thursday, April 24th. House Oversight Committee has requested Bondi appear for testimony. Deadline for response within 30 days. New York State AG's office has indicated awareness of federal framework discussions. Potential state-level inquiry forthcoming. Still unknown. Whether the February 14th meeting involved any direct communication with the president himself. Exhibit C references principles without naming them. What the White House privilege assertion specifically covers, and the scope of that privilege claim tells you exactly what they're hiding. Whether additional DOJ officials will file supporting declarations. 4 came in Friday. Weekend is quiet. Monday could change that. The Wednesday IG decision determines whether this remains an internal accountability matter or becomes a full independent investigation with subpoena power. 4 days from now, subscribe. I'll break down what happens Wednesday when the IG decision drops. That's where we are. Pam Bondi facing an Inspector General preliminary review, Senate subpoena preparation, a House testimony deadline, and a growing list of DOJ career officials filing formal declarations against her. Surface read internal DOJ personnel dispute. But what these documents actually describe is an attorney general allegedly using the full apparatus of the Justice Department to negotiate private legal arrangements for the family of the president who appointed her. Off the books, off-site, outside every protocol designed to prevent exactly this. Wednesday's IG decision determines whether preliminary review becomes formal investigation and whether Bondi stays in that chair. Stories moving. Subscribe for the breakdown when Wednesday's Inspector General decision drops. I read the document so you don't have to. Whistleblower complaint, 34 pages, Exhibit C, the financial framework section, IG preliminary docket, Bondi's office statements cross-referenced against whistleblower White House privilege assertion filing, all of it Wednesday, April 22nd. One way or another, we'll know what the IG found. More coming.